last and final session of our two-day seminar. This session will be in two parts. The first part will consist of the three presentations we shall listen to, followed by questions and answers. And the second part will be on the way forward and closing remarks. So let me start with the first part, which consists of three presentations. The first presentation will be made by Professor Serge Kamunga, and the title of his paper is COVID-19 and the Inclusion of Learners with Disabilities in Basic Education in South Africa, a Critical Analysis. Serge Kamunga is a professor of law at the Thabo Mbeki African School of Public and International Affairs, UNISA, which is based here in Pretoria, South Africa. He is a member of the Building Committee of the Cross-Cultural Human Rights Center, which is a consortium of 1 European university, 10 Chinese, and 4 African universities aimed at bringing Southern concepts and ideas in the area of human rights to Northern audiences. His areas of research interest include the right to development, human rights from a cross-cultural perspective, and disability rights. He publishes in these areas. It is my pleasure and honor now to invite Professor Kamunga to present his paper. And as usual, please, let's keep it to 15 minutes. And for the rest of you, please mute your microphones. So thank you, Professor Kamunga.
Thank you very much, Prof. Good afternoon to you and good afternoon to colleagues and listeners. And I would like to start by thanking the organizers for the opportunity and by thanking you, Professor Fomba, personally for alerting me of the call that was issued to really encourage me to consider sending an abstract. Thank you very much. Well, I have 15 minutes. I will immediately go to the paper. Well, at the center of this paper is the history of exclusion of persons with disabilities. But in this case, I will focus on the case of learners with disabilities during the pandemic. Well, relying on the Disaster Management Act that was discussed yesterday and today, the government imposed lockdown measures to deal with the pandemic. But given the place of education for human development, numerous measures were taken to keep education going. So among those measures, we had online platform, and education was conducted through radio and television. So I will say for all. And I would like to note that the basic education is compulsory and immediately realizable under international law. So there was no way the pandemic could stop basic education, which is the focus of the paper. But the main question here is, to what extent is online-based education in time of COVID-19 inclusive of learners with disabilities? Well, in answering this question, I have structured the paper into 3 parts. I will quickly touch on the first part, that will be to look at the legal and policy framework, legal, policy, and theoretical frameworks for inclusive education in South Africa. Then I will immediately move to look at how education has been inclusive, whether the legal and policy framework were applied to the benefit of learners with disabilities. And I will then move to examine the lessons for the future, with some reflection on addressing systemic deficit in South Africa's inclusive education system. Now, looking at the policy and theoretical framework, In the interest of time, I will be quite brief here. I will simply mention that South Africa is party to all international and regional instruments providing for compulsory basic education for all. And at the national level, we have the constitution of the country that provides for the right to education for everyone in section 29. And this was actually validated by the courts in South Africa through the ex parte Gauteng provincial legislature case, where it was held that education is to be provided for everyone. It's actually a positive right. Many policy measures were also adopted to give effect to inclusive education. At the center of it, the White Paper 6 of 2001 that speaks of inclusive education. From this white paper, we can gather a theory that is used in South Africa. It's called, I call it the reconciliatory approach between inclusive in mainstream education on the one hand and in special schools in the other hand. This is to say, under the South African law, learners with disability should be included in mainstream school as if they did not have a disability in the same classroom with those with disabilities. At the same time, the law also provides for inclusion in special school for learners with special needs. So that in case the disability needs special or particular attention, the learner is not left behind. And this is in line with international practice and normative standard, as seen in the Irish case of Odongwe versus Ireland and Eaton versus the Canadian case of Eaton, where it was clearly recognized that as much as it's important to keep learners with disabilities with their peers without disabilities, it's also important to make sure that in case of certain disability, a special school is provided for. So this is to say South Africa is normatively very compliant with international law and even domestic law for that matter. Now, I want to move to the COVID situation. To what extent was all this implemented during the COVID? I want to look at the exclusion of learners during the COVID, learners with disabilities from school. I want to look first at the mainstream school situation. Indeed, inclusion necessitates what we call reasonable accommodation measures. This is some adjustment needed to ensure that no learner is left behind. But to be able to assess the extent to which all learners were included, let's quickly have a look at the measures taken to give effect to education for all during the COVID pandemic. The right to education was not interrupted, so the government took measures including online resources for parents, caregivers, and learners to support learning at home. The delivery of study material for all grades, multimedia with assessment, audio, lesson, video, tutorial, interactive workbook, lockdown, digital school, and so on. So you even have a full radio education program on SABC that was basically also called accessible to all. There were so many attempts to continue the education. But I argue that in these measures, nothing was done to ensure that learners with disability are included in mainstream school. Firstly, most initiatives rely primarily on computers, tablets, and online learning portals. Virtual lesson and radio TV lessons that are not often accessible to learners with disability, because technically, as we will see below, we cannot take that for granted. Linked to this is the fact that virtual lessons are associated with access to internet, which is not cheap, and therefore not available for learners with disability, generally associated with extreme poverty. Although the government subsidized access to internet through deals with telecommunication networks, internet and broadband penetration remained a challenge in many places in the country, and especially in rural areas where low-rate media access is also a constraint to inclusive education. Now, learners with disability remain forgotten, secondly, because most gadgets such as tablet, computer, mobile phone, and online portal used to provide this education are not equipped with the essential and compulsory accessibility features to make them usable for children with disability. And even when the tools are made with the accessibility feature, they require technology that is not readily available to many learners with disability. These challenges are also real when lessons are provided through television or radio that are not equipped with accessible features. Um, Maclean Klapo, she explained in this way. She says, learners with disability might not be able to hear what the lecturer say. Audio is distorted through technology. Other challenges include absence of closed caption or subtitle, not being able to quickly check with a peer what was said, and not having a manual or electronic notes immediately available to these learners. Uh, so shifting education to online platform without providing reasonable accommodation for learners with disability is simply a discrimination against these learners. The reasonable accommodation of these learners will include subsidies or the provision of computers equipped with accessible features, subsidized access to internet for these learners, and ensure, more importantly, ensure that all lessons on television have sign language interpreters. In doing so, all learners will thus be provided with the necessary and appropriate technology devices to be in class. Now, that is in mainstream school. What is happening in special school is that moving from physical to virtual education deprive learners with special needs from the most needed support that are crucial for their learning success. In this respect, it is assumed that inexperienced parents in special need education shall be at the center of their children's education in terms of supervising their learning, creating a school environment at home, and also teaching substantial content. This is an impossible mission for many parents who simply do not have the requested expertise to be the teacher of their children with special needs. Some learners with special needs may need extra attention, including personal assistance, physical therapy, or an emotional support, and be kept on school nutrition program to be able to sustain their studies. These supports are no longer provided with the shifting of education to online and media platform. The exclusion of these learners is further compounded by the fact that most study material are locked at school and inaccessible from home. For example, assistive devices such as Perkins Braille or video technology for communicating remotely in sign language are also not definitely available at home. So the home environment is not equipped with stimulating tools related to sight, sound, and notion embedded in the education of learners with sensory, physical, and intellectual disabilities. So this is briefly to explain, to say that these learners were completely forgotten. But what lesson can we learn? What can we do in addressing systemic deficit in South African inclusive education? This is basically the last part of my presentation. Before the pandemic, it was reported that 600,000 learners with disabilities stayed at home, and there were no, and look, by then there was no pandemic, but we had 600,000 already at home. So there is a need to increase access for these learners. And to do this, it's important to collect disaggregated data by disability, because this will enable the government to know the number of learners with disability, their gender, and the type of disability, and that those data will be important for disability programming and mainstreaming. Providing reasonable accommodation for these learners is a key at all times, not wait for pandemic, but we cannot wait. We immediately must always make it systemic for the inclusion of these learners. Mainstreaming disability in society should be a must. We cannot just be talking about disability just occasionally. In South Africa, we say we have 11 languages. We should be actually thinking of making sign language to become a 12th language. That's how we start mainstreaming these issues. Providing more special school for the inclusion of learners with disabilities. Just a few years ago, we had the Western Cape Forum case, where learners with disability were selected and educated within NGOs' premises. And the state said they subsidized these NGOs, but very little money was given to these NGOs. But the Western Cape Forum for learners with mental disability took the case to court to claim that these learners were not educated. And the court found for these organizations and called on the state to remedy the situation. Although there's been some progress in terms of ameliorating the condition or improving the condition for these learners, much more needs to be done in making inclusive education in reality in the country. To cut a long story short, I will say the normative commitment for inclusive education should be followed with reasonable accommodation measures if inclusive education is to become a reality in South Africa. And this should be done in normal time to be effective in case of future pandemic. I thank you very much for your attention.
Thank you very much, Professor Kanga, for that brilliant presentation. As you rightly point out, the pandemic has created global problems for learners. And this is particularly so in the case of learners with disabilities. And it's also tested the limits of the principle of reconciliatory approach to education for all. Let us now listen to the second presentation, which will be made by Mr. Woo-Jin Lim. And the title of his presentation is Assessing the Implications of Digital Contact Tracing for COVID-19 on Human Rights and the Rule of Law in South Africa. Mr. Woo-Jin Lim is a legal researcher at the International Justice and Human Rights Clinic, University of British Columbia, where he focuses on anti-corruption litigation research and is working with the UN and the Canadian government on practices for stolen asset recovery. Last year, he was a research fellow at the Edmund Safra Center for Ethics at Harvard University, where he worked with Professor Alison Stanger to present to the Institute of Politics a comparative analysis of digital contact tracing in the United States. His paper is partly based on some of this research. It is now my pleasure to invite Mr. Woo-Jin Lim to make his presentation.
Awesome. Good afternoon to all of my colleagues. Thank you so much for the introduction and for this opportunity to present my work. All right, so I guess let me begin with a brief contextualization of my research and how I arrived at this project. So last year, as you briefly mentioned, I conducted the comparative research project, canvassing coronavirus contact tracing workflows, and in particular, the development and deployment of mobile apps and technologies. So extending on this task in this paper and presentation, I covered the technical and human rights implications of digital contact tracing tools for coronavirus currently deployed in South Africa. So crucially, I find that the establishment of centralized and aggregated databases and applications enabling mass digital surveillance, despite their public health merits in helping to contain the virus, may lead to the erosion of South Africa's constitutional human rights centrally privacy, equality, and human dignity, especially if data surveillance is extended beyond its designated use. I arrive at the recommendation that any proposed digital contact tracing framework in their design, deployment, and implementation must pass the legal muster and adhere to normative human rights prescripts relating to transparency, confidentiality, private information, data privacy and protection, drawing from South Africa's Protection of Personal Information Act, POPIA, which recently became effective on July 1st, 2020, as well as global human rights frameworks such as the UN International Covenant on Civil and Political Rights, ICCPR, and the European Union's General Data Protection Regulation. But before we get onto this, let's begin with some background and some comparative context. So let's begin with the question, what exactly is contact tracing? Conventionally, contact tracing has been performed manually, where a public health worker would engage in a phone or in-person conversation with a diagnosed virus carrier to retrace the past weeks of their lives. The health worker would afterwards, with discretion, identify those in close contact with the carriers and notify them to isolate and seek testing. The main purpose of this practice is to rapidly identify secondary cases caused by the first probable or confirmed cases, track possible routes of infection, mitigate the flaws of detection based only on symptoms, and break the chains of onward transmission. In South Africa, approximately 20,000 people have been trained to assist with manual contact tracing, but at this stage in the COVID-19 outbreak, manual contact tracing is limited due to its labor-intensive processes, which may also be fraught with memory errors. As a result, governments, earlier South Korea, Taiwan, China, Singapore, Israel, and among others, have aggressively pursued digital forms of contact tracing, which include mobile apps or Bluetooth networks that expedite an existing manual contact tracing operation and make it more accurate by finding close contacts that were unknown or forgotten by carriers. If developed effectively, digital apps can anonymously and automatically alert potentially exposed users. Databases gathered from contact tracing investigations have been collated and analyzed to view larger patterns, including transmission sites, attack rates, the effectiveness of mitigation measures, contributing to a better understanding of the epidemiology of COVID-19 and assisting with policy formation. Digital contact tracing is vulnerable to technical limitations, however, which include problems of security and access, provided that only 1/3 of South Africa's population regularly use smartphones, and its reliance on triangulation of cell tower metadata, which is problematic both for South African rural areas, which have very few towers, and urban areas where buildings scatter signals. Surely effectiveness and accuracy must be improved, and access must be extended to those who cannot afford reliable mobile connections for reasons of age, disability, or poverty. But additionally, as evident in many countries across the globe, an expanded mass surveillance regime has trailed digital contact tracing and extensive databases, curtailing individual freedoms and exposing some of the most private details of possible coronavirus carriers. The pressure to act quickly in several nations have allowed software with inadequate security features and weak encryption to be rushed out onto the App Store. The proliferation of unprecedented technologies, including geolocation, biometrics, facial recognition, AI, and big data, have offered significant potential to track populations, enforce self-isolation rules, and meet international human rights principles that guarantee every person the right to the highest attainable standard of health. But in spite of the derogation clauses, which recognize that in the context of serious public health threats, restrictions on some qualified rights, for instance, privacy, can be justified, these measures, if taken beyond the scope of necessity, can be prone to abuse. Human rights limitations occurring outside of the standard democratic process must be minimal and treated as exceptions to the norm, subject to careful scrutiny and justification. So then let's take a look at the situation in South Africa. So upon swiftly declaring a national state of disaster, South Africa has declared a digital contact tracing as crucial and non-negotiable. It has since joined several governments in passing regulations that allow for the identification of infection hotspots using technology, surveillance data, epidemiological mapping, as well as the collection and storage of data from mobile companies. Part of these regulations include individual track and trace, on which the internet and digital sectors must provide location-based services to track and trace individuals that have been affected. It also provides that a database may be correlated with other sources from government and the private sector. So building on these earlier developments, South Africa established the electronic COVID-19 tracking database. On written request of the Director General of Health, electric communication service providers that are licensed under the Electronic Communications Act, number 36 of 2005, must provide the location and movements of any person known or reasonably suspected to have contracted the coronavirus. The South African government, in partnership with the University of Cape Town, has also developed and launched a smartphone contact tracing app, COVID-ID, which is a voluntary app that uses Bluetooth and geolocation to collect a data subject's personal information. Significantly, the legal regulations establishing the use of these individualized data for contact tracing goes beyond the initial reported intention of the Council for Scientific and Industry Research, which was to aggregate location data for analytical purposes and to provide evidence for rational crisis response and policymaking. But that said, there remain a few privacy safeguards, including a strict duration requirement, limitation of the scope of the collection of mobile data only for the purposes of contact tracing, and reporting requirements to a COVID-19 designated judge, who is at the time Justice Kate O'Regan. But here I suggest that extended safeguards must be instituted to prevent the normalization of data privacy infringements. A recent interesting development has been the enactment of POPIA on July 1st, 2020, which is the Protection of Personal Information Act. It's sections 2 to 38, sections 55 to 109, section 111 and 114, which has been a work in progress since it was earmarked for implementation by the South African Law Reform Commission in 2005. Essentially, this act provides for a general information protection mechanism, which is applicable to organizations in both the public and private sectors. It establishes 8 critical conditions for lawful processing of data, including accountability, processing limitation, purpose specification, further processing limitation, informational quality, openness, security safeguards, and data subject participation. So given the wide-ranging impact of POPIA, it's provided that all the processing of this personal information must conform with POPIA's provisions within 1 year after its commencement, which is a 12-month grace period which ends on July 1st, 2021. But between now and then, its implications for digital contact tracing yet remains unclear. And this is precisely where we have to dig to ensure that the handling of personal data is for the sole purpose of scientific research and for digital contact tracing, and that it is in compliance with the fundamental rights to privacy and personal data protection. So one of the key reasons behind the delay of POPIA was the publication of the European Union's General Data Protection Regulation in 2013, which gave time to ensure that the South African privacy regulator could develop operational capabilities. So POPIA and GDPR overlap in nearly all areas, which means that compliance with GDPR should result in near perfect compliance with POPIA. As POPIA's older cousin in Europe, OECD guidelines, privacy guidelines, and the GDPR in tandem provide a yardstick by which to measure South Africa's respective national privacy laws. This situation is very much developing as of presently, as POPIA has been recently enacted, and we are in the midst of the 12-month grace period. That said, insofar as combating the mission creep of invasive and surveillance technologies, the government must invoke extended COVID-19 regulatory safeguards in light of POPIA, as well as with international human rights conventions, in order to ensure the secure collection, storage, distribution, and processing of personal information. Providing human rights instruments as safeguards is indispensable for the increased uptake of digital contact tracing, social acceptability, and public trust, which would in turn make people more likely to follow public health recommendations. So where possible, in its very construction, digital app designers should attempt to build in decentralization, anonymization, and encryption protections into the data collection process themselves, for instance, by avoiding centralized databases, not identifying proximity or interaction data, and adopting Bluetooth exposure notification systems and QR code scanning. Knowledge sharing of these best practices among cross-sectorial interventions, in addition to independent oversight, must be encouraged in order to maintain responsible data collection and processing standards. Part of this framework would involve interoperable compliance with the relevant sections of POPIA about the processing of personal information, as well as with GDPR provisions. So on to some final concluding remarks. The COVID-19 outbreak has paved the way for the introduction of a number of rapid response restrictions on individual freedoms, which has adversely impacted carriers' enjoyment of their human rights. The use of digital contact tracing is an essential piece of a wider strategy to combat the virus. However, it is important to secure limits around the governance of data and technology by setting them out clearly in law, ensuring that any mass data collection is necessary and proportionate, time-bound and limited in duration, respectful of human dignity, non-discriminatory in application, and subject to ongoing review and independent scrutiny. The following issues must be addressed, including inter alia, the justification of data collection, narrow limits around who will have access to the database through, for instance, non-disclosure agreements, access logs, and strict access role distribution, guarantee of secure storage and deletion of sensitive data when no longer needed, with perhaps storage timelines, transparent measures that inform data subjects about the type of information that is collected, robust review and independent oversight mechanisms, and confirmation of an individual's ability to exercise other fundamental rights and freedoms once these lockdown measures are eased. Transparent public communication about contact tracing protocols for the common good should be issued in line with emerging legislation and must continue to carefully monitor new forms of digital contact tracing, as well as their technical nuances that might pose a threat to global human rights. Thank you.
Thank you very much, Mr. Lim. I think this is really a very important paper. You've really highlighted the objectives and the advantages of digital contact tracing in trying to control the pandemic. You've also noted the mass surveillance regime that has come with this digital contact tracing. The question is whether we have sufficient legal safeguards to protect the privacy of individuals. I'm sure there will be many questions on this during the discussion. Let me now invite our third presenter, Mr. Kevin Bakulumpagi, whose topic is Exposing Deficits of Regional Economic Communities, the Impact of COVID on East African Community Integration. Mr. Kevin is a Ugandan lawyer and an advocate of the High Court of Uganda. He holds a Bachelor of Laws degree from Makerere University and a master's degree in Regional Integration Law from the University of Dar es Salaam, Tanzania. He currently works as a research fellow in Advocates for Natural Resources and Development in Uganda. He is also a public interest litigation fellow at the Center for Strategic Litigation in Zanzibar. Among his major areas of research interest are East African community integration, cross-border trade, social and economic rights, such as the right to an adequate standard of living, right to clean and healthy environment, and the right to food. Mr. Bakulumpagi, you will now have the opportunity to present your paper, and we look forward to it. Thank you.
Thank you very much. My name is Kevin, as has been mentioned, and my paper is titled Deficits in Regional Economic Integration and focuses mainly on the East African community. Now, in this paper, we examine the regional integration process and how COVID-19 has interrupted the process, or in the end, shown the weaknesses in the integration process, and using East African community as the case study. Now, we know that the regional economic communities have these treaties that have very rosy provisions regarding integration. But each country adopted a variegated approach, and we are trying to examine how that has affected the regional integration, how that has impacted on the principle of globalization and promoted nationalism at the expense of globalization. The East African community has 6 member states: Uganda, Kenya, South Sudan, Burundi, Tanzania, and Rwanda. And among its main provisions, it has issues of human rights, it has issues of rule of law. And in this paper, we examine the fact that COVID-19 has affected these, what we refer to as principles, what we refer to as the basic tenets that the East African community lives for. And we establish that it may actually be more of a political establishment than a legal establishment, given the fact that these countries went ahead to disregard most of the provisions in response to COVID-19. So we are looking at the systems in place, the enforcement systems, the rule of law. How have we been able to, as a community, how have we been able to live up to these provisions that we put in place? So to do this, we are doing it we are using 5 parameters, and these are provided for in the treaty, including which are the objectives of the treaty, the principles in the treaty, the general undertakings, the areas of cooperation, and the organs and how they operate. And we are basing on this to gauge whether we actually lived up to the terms of the law. So among the objectives, I'll pick out a few because the time may not allow me, but majorly the objectives include setting up a customs union as a community, a common market, monetary union, and eventually federation. But now we can see in the COVID response, most of the East African community countries were very vocal on free movement of goods. they actually advocated that they should not close the borders to movement of goods. And we had situations in Uganda where people were telling the president, close the borders from Tanzania, because Tanzanian truck drivers were the ones that were testing positive. And he stated clearly that we need to allow free movement of goods for the purposes of livelihoods of the people and for the purposes of continuance of the community. So here we can state that the community was very vehement in regarding movement of goods, which is an objective in the customs union. But when we go to other objectives like the common market, we see that, of course, it was necessary to ban the people from free movement across the borders, but there had to be some exceptions, some grounds upon which we should base on as a community, because we have synergies together, we have working relationships where would allow a few circumstances. For instance, students. These were stranded in countries, Tanzania students were in Uganda, and the ban was abrupt and blanket. And at least as a community, we expect at the regional level to have coordination mechanisms to have these people repatriated, people who are sick. These are the free movement among the communities. And we see that the wife to the late President Nkurunziza of Burundi was flown to Nairobi for treatment. So we wanted as a community to see that there is a coordination at this level that allows for such movement at a regulated level with subject to the quarantine measures and the like. The other objective is the monetary union. And the monetary union has a convergence criteria where they state that each country should not go borrow, have a deficit of above 6% of its GDP. But a lot of the countries in the community went ahead and borrowed individually throughout COVID to offset the problems they are facing. So we are saying the borrowing is not bad, but we needed the community to regulate the borrowing, to inform the people that actually you're borrowing way above the limit, and you should, in that case, be able to live up to the obligations, because the monetary union has been, the protocol has been signed by almost all the countries in the East African community. So we are saying, as a region, we need to hear the voice of the organs come out and state that this is the convergence criteria. And this was done in the European Union. They allowed for borrowing, but up to a certain percentage, because they realized the ceiling that they had put was not practical in these COVID times. But at least we need to hear the response mechanism of the community come out clearly on this. When we go to the other parameter is the operation and fundamental principles. The East African community in the treaty set up operation and fundamental principles, some of which include human rights, promotion of human rights, good governance, rule of law, democracy. So when we pick on one principle like human rights, we are not going to talk of the individual countries, because this has been clearly talked about by many of the presenters and the facilitators here. But one human rights aspect I can talk about is elections. We had Burundi have elections in this year, May. We have Tanzania having elections October this year. Uganda is set to have elections next year, and South Sudan. So as a community, it is clear there is no structure that regulates issues to deal with elections, yet these have very serious human rights implications. They do not particularly intervene in the election holding process, but they can decide to issue out measures that must be followed so as to have a fair balance with the human rights obligations of the countries in the treaty. For instance, we've had a lot of opposition in Uganda saying these scientific elections, because Uganda is holding what is referred to as scientific elections, elections where campaigns are virtual and the actual election has not yet been determined how it will be operated. So we are saying the community should put its foot on these matters, because they are very, very essential to the body fabric of the community at large. And the opposition in Burundi was still very, very unsatisfied with the way the elections were conducted because of such things, because of lack of inclusion of the opposition. And this in turn shows the weakness of the community in itself to come out and direct on the activities that are going on in the region during the COVID-19. If you take an example of ECOWAS, the paper has synergies between these other regional bodies, and ECOWAS clearly came out through the economic network of the ECOWAS network of electoral commissions to state that you should have a needs assessment, sanitizers and the like that should be used during elections. You should have the dates of elections decided between two parties, opposition and government, so that the opposition does not feel left out or does not feel that the government is pushing an agenda to actually stay in power despite the COVID restrictions. Then we have issues to deal with globalization as a principle in itself. Globalization has been tested heavily by COVID-19 because the entire body fabric of regional integration looks to globalization, which is more of economic integration, harmonization of policies and picking knowledge from one another. So this has been tested greatly because each country went on its own response mechanism. And we cannot say it has been brought about by COVID, but it has been accelerated by COVID, all the way from Brexit. And now we have COVID, and each country is dealing on its own. Kenya, for instance, was negotiating trade deals with America and UK on its own. We have Tanzania having its own approach towards COVID that had laxity in health response mechanisms. And we're saying these have shown that countries are more comfortable dealing with national response mechanisms or national interests as opposed to the regional integration agenda. And this in itself has affected regional integration. It has shown that the East African community has failed to live up to the occasion when we needed it to come out and strongly assert itself in this COVID-19. This has not only been in the East African community. We've seen the EU countries like Poland and Italy blame the European Union for not coming to their aid. This is the analysis that we're trying to make here. We're trying to say that given the body of the law that we have, given the situation in our countries, the East African community had to come out strongly and make sure the countries align their policies, their response mechanism according to the law. The other parameter is the general undertaking. As individual countries, they had a general undertaking as to implementation of the treaty. That means each country, when it signs the treaty, it says that I will do everything as a country to make sure we live up to the obligations that are required of us in the treaty, and that's under Article 8. But there's been a lack of general political will among leaders. Leaders are focused on issues back home, issues of elections. That's why when you had approaches in East African community, there was a half, Kenya, Uganda, Rwanda, that was very strict, lockdowns, churches were banned and the like. But then there's another half, Burundi, Rwanda, that actually left almost everything running as on a normal basis because they were preparing for elections. So as a community, there had to be some strength to it. There had to be some coherence in approach, but we did not see this because there is no political will among leaders to actually have a lasting solution as a community. And we can see that the president convened a meeting, which would have translated into a summit meeting. That is the president of Rwanda, but Burundi and Tanzania suspiciously did not attend. And we expected that this being no movement, no flights and the like, we would have a virtual meeting of heads of state, but they conveniently or suspiciously were not present, showing lack of political will. And issues of sovereignty within the community, again, showing that's a deficit in the community. We know it's an intergovernmental organization, but it has fronted the interests of leaders at the expense or the deficit of the community. And it's again showing the nationalistic tendencies. The other parameter is the institutional operations. We have various institutions, but I'll talk about the summit and the Council of Ministers as well as the Secretariat. The summit has failed to convene a meeting for close to 2 years. That means as a community, there is no summit to give general direction on the flow of events. The COVID-19 situation presented a circumstance where we would expect that the leaders would come together and have a meeting to chart a way forward as a community to talk, but it has failed. And I just submitted my paper, and the next headline of the East African was the President Kagame was saying, the COVID-19 is going to test the East African community. Otherwise, if we fail, there may not be any community anymore because of this lack of cooperation. The Council of Ministers, for instance, also failed to meet to actually discuss the budget. So this has a spiral effect. People's economic rights are affected because they are not paid, or operations of the community are also affected that way. And this is the impasse that we're trying to gauge and say the East African community has failed to rise to the occasion to help its citizens in the community. We have the Secretariat, which is the executive, but it lacks the mandate. It lacks the power to move and do a lot of other things. It only rests on guiding, but it should have the power to coordinate, to act as a secretariat so as to make sure we further the integration agenda. So among the last aspect is the area of cooperation. Health is provided as an area of cooperation in the East African community, but it has been brought to the order paper by COVID-19 by default. We have institutions that the East African Health Research Commission, but this is for only research. We have set up ad hoc measures like the East African COVID-19 response plan, the task force, but all of these are ad hoc measures. They are not institutionalized, they're not structured measures we have in place as a community. And in comparison with the ECOWAS, we have the West African Health Organization, which has been in place due to the trials that were presented by Ebola in the region. So as a community, we are going to have structures in place so that we don't wait for another pandemic to deal with these extraterritorial issues. We have, the paper looks at analogies with the European Union that I've talked about and ECOWAS, but in ECOWAS, I wanted to pick the element of leadership. ECOWAS, when they met, they decided that we're going to have a leader for a task force. As countries, they elected the Nigerian president, Buhari, to be the leader of the response. Having a leader is something that we cannot dismiss because it helps have a coordinated response mechanism. For example, SADC also had South African Development Community. It had an aspect of information sharing. If you go to their page, they show information of how human rights have been abused, of the impact of COVID on the economies, on trade, on HIV, and all these help to have the information sharing helps to come to common grounds among countries, to know the status of each and every country. So to conclude, what is next for the East African community? There is a radical recommendation that countries should desist from these glossy obligations that involve human rights. Areas of cooperation are very many, and have only those areas which they believe they can sustain. And this is the area of trade. If the communities are only stuck on matters of trade, then let that be it. Let us prevent this aspect of digging into very many provisions and putting all these glossy provisions that we throw them out of the window and operate on our own. We should reduce the areas of cooperation if that is the case. But if we are on the agenda of integration, then we should do more integration. We should increase trade amongst each other. We should have a human rights-based approach as the East African community to this COVID-19, catering for rights to education and the like, because as a community, we need to have these synergies, aspects of cooperation with institutions like UNESCO that promote rights to education, rights of the vulnerable people, instead of having just a blanket individual response mechanism. We have institutions to set up. I've talked about this. We have health institutions and these command centers or response institutions that we have to have in place in case of emergencies like these. And this we can learn as a community. We have to, from now on, as a community, we need to have a more coordinated approach. The community needs to come out to be seen to work towards having a regional approach to many aspects, economic recoveries, stimulus packages. Each country has its own, and some of the countries like Burundi, when they're reading their budget, did not highlight the economic stimulus packages that they were going to give to the businesses that had suffered under COVID. So in conclusion, the COVID-19 pandemic has exposed the community with the lacunas that it has, and it is up to the members to come out and clearly show that they are going to work towards more integration than regression, and that when we move from here, either we are moving forward with the integration agenda, or each country now sits back and works best what is best for its country, only promoting trade, which is clearly in the interest of each and every country. Thank you very much.
Thank you very much, Kevin. And I think I like your concluding statements that the pandemic has exposed the weaknesses of the East African community to help its member states to deal with a serious challenge like this. We've now listened to all the three papers. They've raised very important, critical issues. And I will now invite everybody or anybody to comment on this or to pose questions to the panelists. So the floor is now open for discussion. Do we have any hands showing? Trésor. Trésor? Simpiwe, are there any hands up?
I can see that Joseph's hand is up. Joseph Akech.
Okay, Joseph, please can you go ahead and pose your question?
Yeah, thank you. I have a question for Kevin. Thank you very much for a very interesting presentation. I think you highlight the practical challenges we see in how the East Africa community is functioning. Do you propose, I've listened to your recommendations, but I just like to know whether you propose that the harmonization that you advocate would come within the premise of the legal framework establishing the East Africa community and subsequent policies, or are you looking at a collaboration that should be informed by these pandemics and the nature of the pandemic, such that the community should be able to look beyond the processes that are established? Because as you rightly said, the mechanisms are still meeting, albeit with challenges. What we have seen is the problem is the fact that some members of the community do not trust the way in which other members have managed to respond to the pandemic. And so opening borders, for example, was feared that other countries are reluctant. Others have actually dismissed the fact that COVID-19 was there. And that also includes the challenges we have in the member states, the ability to manage pandemics like this. So harmonization would then, as a community, would be informed by the capacity of the member states, which is lacking in many respects. I mean, South Sudan health facilities are very poor, and so if we were to allow movement, other countries will say, but we don't trust what's happening in South Sudan because we think that you're not managing well, and other countries will do the same. So are you therefore saying that mechanisms of collaboration should come outside of the existing mechanisms, or basically strengthening what exists? Thank you.
Before I give Kevin an opportunity to respond, are there any other questions? I think I see one here from Peter Wendo, and he says, and I think this is addressed to Kevin. The East African community's rift between Kenya and of this pandemic. Member states seem non-committal on many regional initiatives. What is the future of the East African community? That is Peter's question. And let me also add to that question, and it's probably linked a little bit to Joseph's question. Do you think the existing legal framework gave the East African community enough leeway to intervene and coordinate activities between the member states? Is there any provision there that foresaw such pandemics or emergencies and provided for measures that the community could take to assist? Are there any other questions, any comments? Okay, if not, let me ask a question to Professor Kamga. If we assume that there will be more such pandemics in the future, or that the COVID-19 pandemic will still be around us for some time, what changes to the law should be made to cater for children with special needs? And to Mr. Lim, what safeguards do you think need to be put in place to deal with this whole, the dangers that go with digital contact tracing, in spite of its numerous advantages? Are there any further questions or comments? For those who don't want to talk, you are free to use the chat box. Okay, I see another question there from Mr. Tami. He says, do you think that the closed door policy has no contribution to restrain the pandemic? I think this is of a general nature, and I suspect it applies to all three of you. Do you think that the closed door policy has no contribution to restrain the pandemic? Now, let me give the presenters an opportunity to respond to the questions. I will start with Serge Kamga, Professor Serge Kamga.
Thank you very much, Prof, for the opportunity to respond to the question. Well, I'll start with the first one related to what changes to the law. Thank you for this very important question. I think in South Africa I think we have some very good laws and policies. Well, when we say the constitution is transformative in South Africa, really this concept came from the need to transform the society into an egalitarian one inclusive of persons with disabilities. So the law per se might not be enough, but what we have in terms of legal provision can actually do some good jobs for the inclusion of persons with disabilities. The problem, in my view, is the implementation of this law. Because as discussed during the presentation, we have an inclusive policy, the White Paper 6, that is not ambiguous in saying we should provide for inclusion in mainstream school as well as in a special school. But the problem, I will say, the implementers or the government does very little in terms of giving effect to Section 29 of the Constitution. So the Constitution per se is not the problem. Is why are we not implementing these laws to the benefit of students or learners with disabilities? We keep saying there is no resources, there is no money, but the real problem, in my view, if there is no money, all sectors must feel that there is no money. But why only learners with disabilities? They appear to be an add-on. Yet the Convention on the Right of Persons with Disability, ratified by South Africa under its Section 24 or Article 24, yes, clearly asks the government or state party to ensure inclusive education. So the laws, in my view, are there, the policies are there. And we even have the White Paper on Disability that also was adopted in 2015, aiming to still foster the inclusion of persons with disabilities. But persons with disabilities are always seen, they are seen as an add-on. When adopting policies, it's like they don't think of persons with disabilities. So we need simply, and that's why yesterday I was saying, we need to have civil society pushing the issue of disability forward every day. Yesterday already I was saying we cannot dismiss the contribution of civil societies if human rights are to be realized. And the South African landscape is a particular example for that. So while the law could be improved, I think we need to seek ways to implement laws and make sure that government officials or the executive or whoever is the implementers, for me, the government should be held accountable for their commitment to this law. And we see it with Section 27 taking the state to court, forcing the state to implement the right to basic education. in the country for all, including persons with disabilities. That's for the question, the first question. The second question, if I was to weigh in and say the closed door policy, I think in my view, in terms of regional integration, the closed door policy could be necessary. But as Kevin said, it should be done in an harmonized way. If you have a policy that says free circulation of people and goods, and suddenly on your own you are in SADC, where we are in South Africa, you close the border with Zimbabwe in the name of COVID without discussing with your SADC peer, then there is a problem. We need a coordination, a good coordination to ensure that all this thing comes together for the entire region. And if we have a good coordination at sub-regional level, that can extend to the entire continent, where head of state or their representative can build on what has been done at a sub-regional level. And perhaps to end with the question from Peter regarding the ESA, I think regional integration, the challenge, one of the challenge faced by regional integration is that it's always from the top. We should find a way to have regional integration from below, where you have people-to-people relationship. We should get to understand that even if you have a legal architecture for these things, and the implementers are not very much, they keep protecting their sovereignty, we need to involve people from people. And this, again, civil society organizations in all these regions have a capital role to play. I thank you.
Okay, let's now go to Mr. Lim. Please, can you respond to some of the questions directed at you?
Yeah, well, thank you so much for some of the questions that you guys have put out. I think first off, and I haven't touched on this as much in my presentation, but I think talking about equity concerns as well as like the marginalization of particular groups is really important. As Kevin said again, doing this in a very harmonized way in which we don't exclude or preclude those who don't have access to smartphone technology and the necessary tools to be part of digital contact tracing in the first place, I think is really important. Another interesting angle is in terms of domestic abuse as well as violence against women and girls. Some experts actually worry that digital contact tracing might even become like a tool for abuse if the location details of survivors are leaked to perpetrators, which has like a likely chance of happening, as well as in addition to the domestic violence and child abuse spiking in the number, frequency, and intensity during the lockdowns. So I think what kind of impact digital contact tracing will have on particular groups who are at the margins and fringes of society is really important. To put forth more comparative examples, like I'm not too familiar with countries like Angola, but for instance, in South Korea, they used patients' GPS data, credit card history, and closed circuit television data to track and trace locations of the confirmed carriers. And though the data was anonymized, movement histories were detailed enough for people to actually identify a particular patient, and in some cases harass them and chase them down in so-called witch hunts. And there were even hospital doctors stating that their patients were more afraid of being blamed and targeted because of the coronavirus than actually dying of the virus, which just speaks to the concerns of where and what these digital contact tracing rules and perhaps their downsides could be abused for particular groups. In China as well, the telecom data analysis platform actually is creating an environment of fear amid a lack of transparency, as well as like suspicions that, like concerning where the data is going to, and that a part of the data is actually going to police officers, like beyond its uses of combating the coronavirus. And so I guess transitioning to the issue of like ensuring adequate access on all parts. One big part of it is in terms of like cell data triangulation, in that like certain rural areas don't have access. And at the start of the lockdown, the president announced that they were working on like an automated tracing solution, but the system that they came up with was way too inaccurate to actually have any like impact. And Oxford researchers have actually predicted that around like 60% take up of a digital contact tracing would work best, though like a lower rate of engagement might still contribute to a reduction in cases. So I guess in terms of accuracy concerns as well as like effectiveness and who, in terms of like who has access to these digital tools and resources, these are just like considerations to bear in mind. And as we move forward with digital contact tracing, sure, it's effective. It may be effective for a certain proportion of the population, but balancing that with manual contact tracing and like other efforts for those who do not have access to these digital tools is really important. As for safeguards on the front of like what safeguards are necessary to prevent or curb digital contact tracing from going beyond and becoming like a tool of abuse, is I think first off like a strong commitment to ensuring POPIA provisions and sticking to some of the main principles that I've listed in the presentation, which include transparency as well as accountability, as well as having like a limited storage term use in terms of, I think it's like 6 weeks after the state of disaster is revoked. That's when all the data should be deleted. I think that's the current provision. So sticking to those provisions, but also being mindful of how the digital contact tracing situation is developing and following up with those developments is really important.
Are you done?
Yeah.
Okay, thanks. Now we'll end with Kevin. I think he had quite a good number of questions. So Kevin, over to you.
Yes, thank you very much. To address the first question by Joseph, it has to be both ways, because you're inquiring whether it has to be harmonization in the legal aspect or in the subsequent response mechanisms that we are going to develop from COVID-19. It has to be both ways, because the legal aspect exists, and this in a way answers Professor Fombard's question. We have the law, and we have Article 118 of the ESC Treaty, which shows that countries should cooperate in matters of health, and more so should come up with joint approaches in the event of epidemics or pandemics or outbreak of communicable and non-communicable diseases. So we have the laws, but it is the willingness to act by the countries, which again brings in the second aspect that Joseph was talking about. The countries are less willing to fork out some money to have these institutions in place. And that means when the issues arise, each country retrieves to its shell and operates on its own. And it comes down to, we need the political will, because these intergovernmental organizations majorly are run on the will of the presidents. If the president does not direct the Council of Ministers and all the other people, their efforts are useless, they are rendered useless. So it comes down to the political will, cede some sovereignty to the community so that it operates as an overarching organization. And when it comes to, we need to strengthen the legal framework, yes, but more of the implementation aspects, because the treaty has so many provisions. We have cooperation in culture, environment, human rights. It's a full spectrum. And some writers like Professor Koti Kamanga have said it was trying to put everything they want in the law, yet they are not going to fulfill the same. When we go to the issue of the closed door policy, I thank Professor Sarges because he actually answered the question. Individual policies are good, as the closed door policies, they are good, but to a smaller extent. And that is the reasoning behind regional integration, that you can develop individually, but when you're many, it is better. So here we have the policies, they may work at the national level, but if they are extrapolated to a regional level, it becomes a better approach. It prevents instances where in Uganda, 80% of the cases are arising from truck drivers from Tanzania or from Kenya. So if you had a regional response, how do we test? Are the test results accepted in this country or because of the standards that you tested at in the other country? That would help reduce these cases. It would help have a system in place that would help easier movement of goods, easier movement of these truck drivers, and at the end of the day, promote integration. And yes, I also agree with Philip that these individual approaches have threatened regional economic communities and the East African community, if it does not check these individual approaches to each and everything, because we have more of bilateral integration. Kenya and Tanzania or Kenya and Uganda work out a way to allow their truck drivers, excluding Rwanda. Rwanda and Tanzania have an arrangement, but this is a community. So these individual approaches threaten the very basic of fabric of regional economic integration, and the East African community must come up to implement the laws it has, to implement the protocols and the directives by the various organs of the state. Thank you.
Right. Okay, Kevin, thanks very much. I think there were a few questions here. Some have already been responded to. Let me just go through them and we see what is still outstanding. For Bernadette, she said, also in relation to regional contact tracing, will it not exclude the disadvantaged or vulnerable population? And how effective will it be in countries like Angola? I think Mr. Alim touched on this. And then Kechidim, he thanks Professor Serge Kamba for his presentation. And his question is, or her question is, do you think that this global crisis is presenting an opportunity to rethink the need for an inclusive and accessible educational system, especially with regards to those in lower socioeconomic standards and those with multiple disabilities? And I think for Mr. Lim again, what legal safeguards are there to curb against misuse of people's personal information? That's right, privacy and so on. I don't know if you answered this already, but let me see again. I think Mr. Tami, where is the balance between the implementation of human rights standards and responses of COVID-19, especially those lockdown measures? I think this is of a general question to all three of you. And I'm trying to see here. Is there another question? I think this one is from Lim. You've spoken eloquently about the legal and normative considerations on how basic education should be inclusive of learners with disabilities. But in implementing this law, provided that education in many places has transition online, what are some ways and resources that we can draw on to create a successful virtual learning environment for students with disabilities? That is the question to Professor Kamga. So let me leave you to respond to this. I start with Professor Kamga.
All right, thank you very much for the question. I'll start with the first one posed by I strongly believe that the COVID pandemic actually offers a huge opportunity for the inclusion of learners with disabilities and multiple disability, as you put it, as well as those who are at lower standard of socio-economic development or the very poor. Well, especially talking of the very poor, my paper focuses on basic or primary education. Primary education, as I pointed out in the paper, is compulsory. It should be realized immediately. This is to say, it's not submitted to the regime of progressive realization. This is to say, inclusive education, the state has no excuses to postpone. The minimum call for this is to have the school available. There is no other way when it comes to basic education. This is to say the very poor should immediately access the school and the classroom to be able to be in class. There is no way, if it's a secondary education, that this is submitted to progressive realization. And if it's submitted to progressive realization, it gives time to the state that must demonstrate the steps taken to give effect to the rights. But at the basic education level, there is no time. The state must make sure it's compelled to do so by international law. That's for the very poor. Now, for those with multiple disabilities, you bring me here to the question related to what I was calling reconciliatory approach in the South African system. Those with multiple disability cannot be forgotten. In fact, because of the question of multiple disability, that question gave some voice to the need to have special schools. So a school with special needs. We cannot be saying a child who has multiple disabilities, let's say who cannot hear, who is hearing impaired, who cannot speak, and who cannot see. You mainstream this child, you include this child into a mainstream classroom, the child is not likely to perform. Therefore, we need a school for special need children, for such children. And this was the position of the court in the Canadian case of Eaton versus Board County of Education, where the court clearly says you cannot simply take a child with multiple severe disabilities into a mainstream classroom. And in the case, but this also, we should avoid a situation where children with multiple disability are simply dumped into a so-called special school with nothing to ensure that they are well educated at the same level with other students. And this was the position of the American case of Daniel Ray versus State Board of Education, where the court put criteria and says, before you send a child with disability to a special school, you have to answer some few questions. Namely, can education in the regular classroom with the use of supplementary aid and services be achieved satisfactorily for a particular student? Has the school taken sufficient steps to accommodate the student in a regular classroom with the supplementary aid? Will the student receive educational benefit from the regular school? So some of these questions compel the state to make sure that they don't simply open something and call it special school, as like in many of our African special schools, where the teacher himself or herself is not qualified to be a teacher for special schools. We need definitely, so the COVID-19 provides a great opportunity to look into those things in building an inclusive education system. And if that's why I was saying, in preparation for future pandemic, the time is now, it's not to wait, because when the pandemic is there, it's almost impossible to do everything at the same time. But we must mainstream disability in our societies. And when there is a pandemic, already you have the structures to address these issues. Now, to the second question by Wu Jing, Mr. Lim, What are the ways? What are the ways? Here we are saying, if you say the ways is to ensure that when you have a special school or you have a teacher speaking or teaching through television, we need to have a sign language interpreter. Of course, sign language is not universal, but in South Africa, we have a specific sign language for South Africa. So every country that has a specific sign language, if this sign language teachers are trained at the school where teachers are trained, when we need them on television, they will be there. The problem is they are not even into policies about inclusive education, and that's why when there is a pandemic, we are stuck. You need to have braille material for those who are blind, workbook, exercise books, all these things. They are not available. If you are a blind student and you cannot, now you have to work at home. How do you work on online platforms? On this platform, even when you listen to a teacher on television or radio, there are some gadgets to assist a person who is hearing impaired. You put them either in your ears or in your earphones. If you are not given those things, you can't. So all these things, you need to have caption and subtitle material for those who need it. And to do this, reasonable accommodation measures include policy, affirmative action policies. This is to say the state must consciously look for budget, for money, to put all these things in place. Otherwise, inclusive education will never happen. That's why we keep saying there is no money, there is no money. But if there is no money, it should not affect only learners with disabilities. Let's have a school of 100 learners. If there are learners with disabilities, there should not be those forgotten when budgetary initiatives are taken. Let's have that there is no money, let everybody suffer that there is no money. And so there are measures that can be done. The problem is not to implement this measure on an ad hoc basis, but permanently in a very systemic way. Perhaps I must give the floor to somebody else. Thank you.
I think the next person who has something to say is Mr. Alim. So.
Yeah, thank you so much for the answer. I guess in response to Peter's question in terms of what legal safeguards are available to curb against the misuse of people's personal information, and if there is nothing in existence, what other things should be considered, I think the Protection of Personal Information Act, POPIA, it was brewing since 2005, but it was very recently ratified a month ago on July 1st. So I think that's an interesting legal safeguard that is in development, but in relation to the COVID-19 crisis, I think more work needs to be done in particularly tying its provisions to the contact tracing database, as well as the contact tracing measures that have been allowed. Other more general available legal safeguards include the global human rights frameworks, including the South African Bill of Rights, including Section 14 on privacy, but it also contains a derogation clause in Section 36. Other covenants like the UN International Covenant on Civil and Political Rights, which touches both on the right to health as well as the right to privacy, though Article 4 provides some derogation provisions, as well as later supplemented by Siracusa principles, which calls for the authoritative limitation of certain rights in response to like a pressing public or social needs, such as public health. In addition, there's also the International Covenant on Economic, Social, and Cultural Rights, which South Africa ratified back in January 2015, which provides everyone the right to the highest sustainable standard of physical and mental health, and that effective steps must be taken for the prevention and treatment of epidemic and other diseases, which actually, is supportive of the public right to health in this particular case. There is additionally the European Union's General Data Protection Regulation, the GDPR, which I've mentioned a couple of times. Its proceedings are mainly set out in Article 5, but also 6 and 9 for legal grounds and derogations. Though it does not have general effect in South Africa because it's not a local law of the country, certain parties that process information in South Africa might still need to comply with the GDPR due to its extraterritorial application. So I think that's those are some possible ways in which we can kind of integrate issues of privacy as well as issues of equity and human dignity into like a human rights legal framework. Responding to Goshaw, in terms of balancing the implementation of human rights standards as well as the responses of COVID-19, I think neither the right to privacy nor the right to health and the freedom of science bears an absolute precedence over the other. So it's important that these rights and freedoms be carefully and responsibly balanced, broaching an outcome that respects the essence of both sides. Because surely there are derogation provisions and certain limitations of qualified human rights, such as the right to privacy, provided like a state of disaster as declared in South Africa. And so just being really mindful of how these normative considerations balance one another out, but also being specific on a case-by-case basis to those who are actually affected by the crisis and how we were able to tailor those rights and freedoms to each and every particular circumstance is important.
Okay, thank you very much. Kevin, I don't know if you have anything to say. If not, maybe I should also just ask you whether there is any awareness at the level of the East African community, that's the body itself, that it could have done more, and or among states, that they too could have tried to collaborate and do something. So is there some awareness that something could have been done which would have helped to alleviate the hardship caused by the pandemic? And I would also maybe also ask Professor Kamga whether you are aware of any specific regulations that were taken during the COVID, during this period of lockdown to cater for the specific needs of children with special needs. Are you aware of any particular measures that were taken? Because the whole issue about opening and reopening of schools has been very, very controversial. It's been very prolonged, and often it looks like there was hardly any mention of those special schools or learners with disabilities. So maybe can you enlighten us a bit? Okay, let me hand over to you, Kevin, and then thereafter we'll listen to.
Okay, thank you very much. To respond to Tamir's question about the balance between human rights standards and COVID-19, there has been a balance, but it has come at very, very tail end of this response mechanism, considering the time lag between now and when the COVID-19 pandemic started. And because in the beginning it was ruckus, it was chaos everywhere, you could easily see the countries one by one instituting sets of emergencies that we've talked about a lot in this conference. And at the time, nobody, not the regulators, not even the people themselves, were thinking of human rights, because even in our country, you could see that activists were numb and mute. It is now at the end, at the tail end, that human rights have been considered and people are saying, no, in these responses, you need to have a human rights approach. So it shows you the place of human rights, of rule of law in the face of troubles and pandemics. It's at the tail end, which should be revised so that each and every response mechanism has a human rights-based approach. There's a question of Mr. Peter that I hadn't answered. What's the future of the ESC? The future is grim. It's a gloomy picture. And it has not only happened from COVID-19, it has been happening over a given period of time. We've had leaders who do not see eye to eye. The deceased president, Nkurunziza, and Rwanda president were not working together. Issues between Rwanda and Uganda that were resolved in Angola, not even in the East African community. We've had blockage of goods and services, and these squabbles between leaders directly impact on the community. And so given the further abyss that COVID has thrown us in, the EAC has a very grim future, and it needs to get up and do more of real integration than what has been referred to as pseudo integration or fake integration, because we need to have technocrats that are running the process, people that are actually with the spirit of integration, which is lacking at the point among the leaders, and more so even among the people who believe each and every time we see members of parliament in Kenya saying, why don't you throw away these Ugandans? Why don't you throw away these? So the picture needs a lot of revising. And then Professor Fombad, you are asking about the awareness. Yes, at the EAC level, there was a lot of awareness that they needed a regional response mechanism, because picking from other regional establishments, you could see that they were coming in to do a lot of regulating, especially cross-border activities and things within the competence of the regional community. And it can be said they put aside a budget for it. They tried to do some response mechanisms, but again, it comes down to the leaders. If the leaders are not willing to talk, and that is what President Kagame was saying in his interview, that people have to talk, because if we do not talk, we cannot get anywhere. And that has been the problem with the EAC. They are aware, they know the law exists, they know the mechanisms can be put in place, but the leaders are reluctant to do their part. Thank you.
Professor Kamga?
Yes, Prof, I am opening the... yes, Prof, thank you very much for the very important question. Actually, you are spot on and say there is hardly any measure or anything that has been done. In fact, that's what some extent motivated me to do this paper. I could have tried to look at a right to development or something else in the context of this. But when I was looking, considering the area of interest that I would like to work on, and I checked working on inclusive education, and I was checking, but so far, yeah, a lot of initiatives addressing the continuity of education. And I kept looking, what is in it for learners with disabilities? What are they saying during this COVID-19? And really, there is hardly a mention of it, even at the primary education level. What they keep saying is, or the government keeps saying, learners with disability will get back to school at some stage, at a late stage. They keep postponing, and you sit and you wonder what is going to happen to these learners. And so I was very puzzled as well, because I could not find things that were done. And very interestingly, my view was that nothing was done. And this view was supported when I was listening on the radio, section 27, now suing the Minister of the Department of Basic Education for doing nothing for the inclusion of learners with disabilities during COVID pandemic. There is a case pending there, I think in the High Court, where the government has to explain what has been really done to effectively include learners with disabilities. When we are talking of education, people see global challenges, but the visibility of the invisibility, so to speak, of these learners is there. It's like they have become uneducable. They cannot be educated anymore. Most of these learners, they live in hostel, in special school. They live in hostel. Now, how do they access, even when they go back, what measure has been taken because some of them are blind or cannot see or cannot move? When they talk of sanitizing the school for people to go back, how will they get into the school? How will they get a mask? All these measures, so many things are lacking for their inclusion into the system. And that's why it is imperative, as Nkechi was asking, we need to use this as an opportunity to say, let's put a systemic transformation for the inclusion of these learners. Because this is like a wake-up call. It could be worse. It's already very difficult, but these learners are basically forgotten, and you wonder, but who are the policymakers? Of course, on a positive note, some money was allocated to increase the transport for these learners in the Western Cape, to build more schools in the Western Cape. But that was the implementation of a court decision in the Western Cape Forum that took place many years ago, not even during the pandemic, where these learners were now asked to, where the government was asked by the court to ensure the inclusion of learners with disability in special school by subsidizing a bit more. So now we can see some sign of that, the implementation of that court decision. But this is taking place because the government is avoiding to find itself not complying with the court decision, the contempt of court. That's the word I was looking for. So the government is avoiding the contempt of court, and that's why they've been putting a bit of resources in the Western Cape for this, for the education of special need learners. But specifically to COVID-19, I am still looking, and I've been combing everything to see, but what is specific, almost, or I will really say, these learners are perceived as non-educable, because when other learners are getting stuff dropped at home, everything, the learners with disabilities are not catered for, because those with special needs that you are asking for, especially those ones, some of them need to have a nurse, they need multiple type of assistance, and they can't benefit from that in their houses. So it's imperative that we use this opportunity now to put a place as a bridge for a systemic transformation of the education system in preparation for future pandemic. Thank you for the question, sir.
Thank you very much, Professor Kamga. I do not know if there are any further questions or comments. If not, we will now move to the second part of this final session. And here we will be involved with looking at the way forward and the closing remarks. Let me start with the way forward. I want to take this opportunity to thank all the authors, those who took time to carry out research, write out the papers and present them, as well as you, those of you in the audience and the participants. I think the quality of the papers was there for all to see. I don't know if you are like me, but I've learned a lot during these 2 days. All that is left for me to do now is to tell you about the way forward. There is a schedule for the submission of the revised papers, its peer review, and the ultimate publication. I want to assume that you, the authors, you've heard the questions, you've heard the comments, and it's probably giving you some new ideas on what to add to or take out of your paper. So what we will do, and that is my first point, is that we will allow all the authors up to 20th August to forward their final paper. So the deadline for the revised final papers is 20 August 2020. Please make sure it complies with the journal house style. That is the African Human Rights Law Journal. Secondly, once we receive your papers, we will send it to 2 anonymous reviewers. They will send us their reports, and we will send the comments to the authors latest 20th September. And we'll give you an opportunity to have another look at the paper based on the comments made by the reviewers and submit the revised paper on the 15th of October, latest. We will only pay the honorarium to the authors on the 30th of October when a final decision has been made with respect to those papers that will be published in the journal. The papers accepted will be copy edited and submitted to the editor of the journal in November. And we are hoping that by December, the journal will be out. There are a number of things to note. The first is that, as I pointed out, there will be 2 anonymous reviewers who will review all the 15 papers and recommend the 10 best papers. So it will be decided by the reviewers. Their decision will be final. Where there is any disagreement amongst the reviewers, we'll leave it to the editor of the journal to make a final decision. I don't know if any person wants to raise any issue at this stage, because I think that's basically the way forward, and I will definitely be writing to you again to tell you all these things. But I don't know if there's any question that anybody wants to ask.
Yes, Professor Fomba, this is Petronelle Kruger. I just wanted to find out, I know a lot of journals use an online platform for submission. Will we be expected to use an online platform, or will we just email the organizers of the event directly with our final papers?
No, very good question. No, you email it to the organizers. So send all the papers to the organizers. It is us who will then submit it to the editor and also give him the reports. Because I had actually tried to negotiate for him to publish all 16 or 15 papers. He told me, no, they can only accommodate 10. So I've seen the papers, and I must say, I don't envy the reviewers. They are all excellent papers. But the mandate we've given them is to select the best 10. And well, we keep an open mind and see if the editor of the journal will change his mind at some stage to accommodate the other papers, but we will see. We'll see what happens. Are there any further questions? If not, I think all what remains for me is to thank a few people who made this online seminar possible. Let me start with Dr. Lukman Abdurraf and Mr. Trezor Muhindo, and I want to thank them for their assistance in the overall organization. I should also mention Professor Ademola Jegede of the University of Venda, who assisted in carrying out the preliminary review of the papers with one other person. On the technical side, I wish to acknowledge the assistance of Mr. Simpiwe Kumalo and Mrs. Yolanda Boysen. I wish to record my appreciation for the support and encouragement I received from Professor Christoph Hens, who is the director of the Institute for International and Comparative Law in Africa, and Professor Franz Quillion, the director of the Center for Human Rights. The same words of gratitude go to Mrs. Emily Lobsher and Mrs. Lizette Herman for their assistance with the financial aspects of the seminar. There are no words strong enough for me to use in expressing my profound gratitude to Dr. Anne Wolf, the director of Konrad Adenauer Stiftung's Rule of Law program for Sub-Saharan Africa in Nairobi, and to his able, competent assistant, and my very good friend, Mr. Peter Wendo, the project advisor on this program. They provided the financial support that made this seminar possible. Finally, I wish to also express my profound gratitude to the authors who took time to do the extensive research on the papers and who raised very many interesting issues that we all discussed during these 2 days. And finally, to all the participants, I hope you all enjoyed it, and I hope this has prepared us for the future and even for the present. With these few words, let me now invite Mr. Peter Wendo to make his final closing remarks. Peter, up to you.
Thank you, Professor Fombad. I think you have actually summed up everything. I thought my closing remarks would just be the vote of thanks, which you have ably done. But on behalf of the Konrad Adenauer Foundation, let me also just add my voice to appreciating all the people who have taken part in this online seminar, which I think has been very good, has gone on very well. And I also wish to confirm that I've learned quite a lot from all the presentations that have been made. Just to reiterate the fact that Konrad Adenauer Foundation, especially the Rule of Law Program for Sub-Saharan Africa, we highly value our long-standing partnership with the University of Pretoria in the promotion and protection of human rights, rule of law, and democracy on the continent. And I particularly love the fusion that we have adopted, where we benefit immensely from the scholarly output from the university and our approach of bringing in practitioners, so that when we address some of these issues, we tend to have a more global view of what is happening. So we really appreciate the partnership that we have with the university. Also from the Konrad Adenauer Foundation side, let me add my gratitude to Professor Christoph Heinz, the director of the Institute for International and Comparative Law in Africa, and Professor Franz Filiun, the director for the Center for Human Rights, both from the University of Pretoria, my own director, Dr. Anne Wolf, who graced the opening session of this seminar, and whose remarks aptly set the tone for this online conference. So I really wish to thank them. I also wish to thank the panelists for their informative, relevant, and very interesting presentations that will undoubtedly enrich the ongoing discourse on how to deal with this current pandemic in an effective and humane manner while respecting the tenets of the rule of law and human rights. I also wish to express our gratitude from the Konrad Adenauer side to all the people who signed up for the conference and those who actually participated in the sessions. We really thank you so much for your input. And last but not least, allow me then to extend our heartfelt gratitude and appreciation to the coordination team under the able leadership of Professor Charles Fombad for the programmatic, logistical, and technical support that you have accorded this session, which went a long way to making it a success. So thank you very much, Professor Fombad and your team, which you mentioned earlier, that comprises Dr. Lukman, Trezor, Sipiwe, Kumalo, and all the rest. Thank you so very much. Once again, as I wrap up, I wish to express our heartfelt condolences and extend our prayers to Mr. James Ngubi from Uganda, who lost his mother this morning. We just want, and all the people who have lost their loved ones during this difficult time, we just want to extend our condolences, and we pray that God shall grant you all the comfort that you need. So from us and from Nairobi, I just wish you all good health, take care, and kindly stay safe. Thank you so much.
So before I finally say bye-bye to everybody, let me apologize. I know there were about 86 abstracts that we received, and we were only allowed to look for the best 16. I must say there were many, many excellent abstracts. And besides that, I think it's not a coincidence that many of those who made presentations are people I've worked with in the past, like Professor Muiza John Carter, Dr. Itumeleng Shale, Dr. Musa Shongwe, and so on. So I'm hoping that this is the beginning of a long-term relationship with the others, those of you who participated and those who again made presentations. So let's keep it up. As we said from the very beginning, this fund is not going to disappear tomorrow. So we have to continue discussing how to deal with it, how to ensure that it doesn't compromise our hard-earned progress in constitutionalism and rule of law. So I wish all of you the best, and let us keep in touch. Bye-bye.
Bye-bye, Prof. Thank you very much. Thank you very much for putting this together. Thank you to you and your team. Thank you.
Bye-bye, everybody.